Now live and recording. Bashan, Brynelson,
Present.
Falmouth,
Here.
Fleischman,
Here.
Hamilton,
Present.
Hartston.
Here, good morning.
Good morning. I think that our Chris Iglesias is not joining us. Kirkmeyer, McRae, Olvera,
Here.
Shining.
I made it.
Great. Sarush. Sarush. Okay. Spyro.
Here.
Torres Ambris. You. And I think, did I see Sharon Bashan, you joined?
I did.
Okay.
Present.
And I got an email. I'm going to just check real quick.
Okay, while Linda's doing that, she mentioned Chris is not here today, so I want to ask if any of the working group members might want to volunteer to serve as chair. That would involve just kicking off public comment, essentially today. Any takers?
Hello. Do you want to start your practicing being a judge?
Amos, that was a handoff to you.
And I also see that,
Claudia and Fariba.
right.
Good morning.
It looks like Amos is not volunteering. I'm happy to serve in that capacity today if folks don't mind. Let me start off by just seeing if there is any public comment.
We have a number of attendees. I want to invite any members of the public who would like to make comment to indicate so by raising your hand. In the bottom center of your screen, there should be an option to raise your hand. And if there, I'll give a minute. There's a couple people.
Okay.
I see a couple of raised hands.
Right. We'll get started while other people have the opportunity to raise their hands. We'll start with Julie LeBlanc. Okay.
Good morning. My name is Julie LeBlanc, and I just wanted to let you know that I'm attending the meeting. I'm a member of California Association of Legal Document Assistants, and I'm a legal document assistant located in Livermore, California. Thank you.
Thank you, Julie. Miriam Bianco. Miriam, you are on mute. Okay.
Oh, hi.
Not sure what happened to Miriam.
Let me try her again. Hold on a second.
Unmute. Hi, can you hear me?
Yes, we can.
Yes, hi. Miriam Bianco, and I'm also a member of the California Legal Document Assistant, and I'm in Los Angeles County.
Thank you. Julia Gonzalez.
Morning. My name is Julia Gonzalez. I am also a member of CALDA. I am in Kern County here in Bakersfield, and it's more lower income community. So I'm very excited. I'm a new LDA, so I'm very excited to bring access to justice to all people, not just people with money who can afford attorneys. Thank you.
Thank you. Helen Bellamy.
Morning. Good morning. How are you? My name is Helen Bellamy. I am a legal document assistant, but more so, I am a citizen of this great United States. And I've talked with you before with reference to making sure that this committee understands that legal access is a right for all of the citizens, and that you have a great duty to make sure that as you walk forward, that you give the legal consumer as much services as possible with as many choices. It is not just, I've said this before, the legal consumer has a right to find and to have their legal issues addressed. And as a consumer of legal services, I don't necessarily have to have only one choice. So if I can go to lots of different places to find what I need, the better. So please keep an open mind. I'm asking, imploring that you keep an open mind to allow me personally to get the services that I need, and also as a legal document assistant to be a businesswoman with and making sure that I understand how to assist the legal consumer. I hope you understand what I'm trying to say, that this is very important work. This is not the first time. It's been a long time that we've been trying to open up the legal services for the consumer. Okay. Thank you.
Thank you. Alan Uzzell. Alan. Alan.
I don't see, it doesn't, we've unmuted your microphone, but we aren't able to hear you. Perhaps we,
Let's try Stacy Weissman.
Good morning, everyone. I just wanted to say hi. I'm here. I am also with CALDA, and I'm very excited to be a part of this process. So thank you.
Thank you. Alan. Okay. I'm not sure what's happening with that sound, but Alan, if you're able to speak to us, now's the time. Otherwise, I'm going to close a public comment. All right. So I think that that's all that we have. And I'm just going to briefly introduce Becky Sandifer. I'm really pleased that she was able to join us today. As you all are aware, we had originally hoped that she could be with us for our meeting on the 29th. That did not work with her schedule. And so we're very grateful to Professor Sandifer for accommodating us today. Just very briefly, we are graced with a MacArthur Genius today. Professor Sandifer won the award in 2018 for work that is directly on point with what we're doing here, promoting a new evidence-based approach to increasing access to justice for low-income communities. She's a professor in the School of Social and Family Dynamics at Arizona State University and a fellow with the American Bar Foundation. So Professor Sandifer, take it away. Thank you so much.
Thanks so much, Leah. It's really a delight to be with you this morning. I'm going to give I'll try to keep it short. I'll try to not be a professor presentation that's kind of an overview of some evidence about some important aspects of thinking about the justice gap and how non-lawyer providers might play a role. And then of course, I'm really looking forward to the conversation that we can have together. So I'm going to share my screen if I can do that. Let's see, there we go. All right. There we go. So in thinking about the justice gap, I want to address three, let's see if we can make this do what it's supposed to do. There we go. Three parts of the conversation around this. So one is, what evidence do we have about America's access to civil justice crisis? Like, what is it and how big is it? What evidence do we have that would make us think that providing a greater range of alternatives or of choices would help more people get help? And what makes us think that those new kinds of providers might do a good job? Because it wouldn't be any improvement if they didn't do a good job. So for this first part, I just want to talk about some different ways of thinking about and then measuring America's crisis and access to justice. So if you look at the conversation around the country, the crisis gets defined in different ways by different people. So some people think of it as being centered mostly in the courts, and then some people think of it as being centered outside the courts. So we certainly know that in particular kinds of cases, especially family, eviction, and debt, people appear unrepresented at the rate of 75% of the time, 95% of the time around in different jurisdictions around the country. So there are lots and lots of people involved in formal court processes with no known legal assistance. Another kind of court-based way of thinking about the crisis is the courts themselves have been under-resourced for decades. The Great Recession made it worse. COVID has made it worse again. And so they're just not adequately resourced to provide prompt, efficient resolution to the really high volume of stuff that comes through them. And then there's another way of thinking about the crisis, which is to step back from courts and think about the justice problems experienced by the general public, whether or not they ever become court cases, and seeing that many of those justice issues involve really fundamental parts of our lives, like being able to make a living, having a place to live, caring for people who can't care for themselves. And many people confront those situations with no kind of expert assistance at all. And when we talk about a justice gap, we're usually not thinking about how courts are overwhelmed. We're thinking about people either already involved in court cases with no help, or people facing justice problems with no help. And a lot of our information about that second part of it, but also part of our information about the first part, so unrepresented litigants or people with problems receiving no help, comes from justiciable problems surveys. And these pick some, representative sample of the population that you care about, and it asks them not about legal issues for reasons that I'll explain in a minute, but about specific problems that lawyers have identified as justiciable, as things that people could take legal action on either side or both sides if they wanted to, but they may never do that. So these surveys ask people, for example, does your employer owe you overtime and isn't paying it? And that's wage theft, but we don't require the person to understand that it's wage theft. We just require the person to understand that they have that specific situation. Or are you 3 or more months behind on your rent? Well, that puts you in violation of your rental agreement and therefore at risk of eviction. And again, you don't need to understand that. You just need to be able to report this fact about your life. And the reason that we phrase these questions in this way is because other research shows us that if you bring up law, people forget about all kinds of justice problems that they have. So if you say, what kinds of legal problems do you have? People will say, I had to probate a will, I had to get divorced. And you can see why they would say that, right? Because there's no way to get divorced without going through law. There's no way to probate a will without going through law. There are lots of other justice problems that people are experiencing, but they aren't forced through one resolution to them. And so they don't necessarily associate them with law. So you do something very straightforward. You take this representative sample, you ask people whether they've experienced some list of problems in the period that you care about. So it could be the previous year, it could be the previous 2 years. And then you ask, okay, what did you do when you had this problem? And when you do these surveys, you're taking an approach to justice that's now understood as people-centered. And you see this in a range of different places. So Canada was putting people at the heart of the justice system. The OECD is talking about people-focused innovations. There's a group out of the Netherlands that calls it user-friendly justice. But the idea is that it's the perspective of the public that's going to define justice experiences and the solutions that we offer them. And part of this activity is related to the Sustainable Development Goals. So the last time they pushed them out, they sort of expanded 16 and made it into peace, justice, and strong institutions. And access to justice is an important part of that. And these surveys are an important part of the Sustainable Development Goals because the goals have to be measurable, right? That's part of the model, is that you have benchmarks and you can show progress or regress. And so these surveys are a way in which we can assess people's access to justice and progress towards these goals. So these surveys around the country and around the world show some very similar things. And one of them is that people have lots and lots of civil justice problems, and many of them fall in core areas of life. So the World Justice Project did a really interesting, it's 101 countries, I think, in 2018 and 2019. And if you look at their results for the United States, 2/3 of adults reported at least one problem in the previous 2 years, And they fall in areas that you would expect for an economy like ours. So there are consumer problems, there are problems at work, there are family issues, there are housing issues, and there are money issues. And California looks very similar. So California also asked about health. So there's almost 30% of households at all income levels in California, based on the State Bar's report some justice problem, at least one justice problem related to health. You got another fifth talking about money again. You got another 15 or so percent looking at employment. There's a chunk of folks with rental housing problems. There's a chunk of folks with family problems. The specific rates differ across jurisdictions, but the prominent problems are the same around the country, at least so far as we know from the research that we've done. So lots of problems, and they fall in core areas of life that have to do with having a place to live and taking care of your family and being able to make a living. Now, there are other sources of information that validate this idea that there's a lot of justice issues, and these come from government surveys and Matt Desmond's eviction lab at Harvard, and different kinds of interest groups like AARP that are thinking about the problems of their members and gathering data on those. So if you think about people facing formal legal action, and all this data is pre-COVID, you have 3.5 million evictions filed every year pre-COVID. You have 4 million people having their wages garnished for debt pre-COVID. You've got at least 1.5 million guardianship actions. And that's stuff where people are already in the system being worked on in some way. But then there's all this other stuff about life situations that raise civil legal issues and may not have made it to formal legal action and may never make it. So before COVID, you had 7 million people behind on their student loan payments and therefore at risk of default. You had 2.5 million grandparents raising grandchildren, which sounds quaint, but it means you've got to have guardianship or power of attorney to enroll the kid in school or get them vaccinated or attach them to health insurance. We've got almost 16 million people caring for an adult with dementia, which can involve the need for legal instruments around limited or complete powers of attorney and so on. And again, pre-COVID, we had over 8 million people living in housing where conditions violated whatever the municipal housing codes were. So they were moderately or deeply unsafe and unhealthy. So an enormous amount of this activity happening around the country. And then of course, since the middle of March, there have been over 40 million new filings for unemployment. So that's over 40 million new people who used to be making money from their jobs and now aren't. And that means they can't pay their bills and they can't pay their rent and they can't fulfill these various other obligations, which are going to create more of these problems for people around the country. And these problems are impactful as far as we know. That World Justice Project survey, as well as some other work that I've done, asked people, okay, so you said you had this problem, what did this problem do to you? And if you take that and you use census data, you see a lot of people affected in very powerful ways by justice problems. So about 19.5 million pre-COVID again led to impacts on health, either mental health or physical health. 18 million made people either lose their job or income or housing or all three. 13.5 million led to damaged relationships. And then almost 5 million led people to say, you know what, as a result of this problem, I developed a substance abuse issue. Another way of thinking about this is like, how much of people's lives do they spend either dealing with these problems themselves or with these kinds of hardships that the problems create? And so if nothing changes at all, you can expect in midlife that you're going to spend over 2/5 of the rest of your life, however long you live, dealing with civil justice problems of one sort or another. And if you're in early adulthood, you can expect that 1/5 of your life is going to be overshadowed by one or more of these consequences as a result of the civil justice problem. So lost employment, substance abuse issues, health and negative health impacts, and so on. So these are quite impactful issues that people are experiencing around the country and around California. The other thing you see in all these surveys is that most of these problems get no legal service of any kind. So in the US, the conservative estimate would be in every year sees 150 million new justice problems. And the little red piece of the pie is the share of those problems that get any kind of expert assistance, any kind of legal expert assistance. California is a similar pattern. So a really conservative estimate for California would be 9 million new problems every year. And again, it's only a tiny portion of those based on whether you use the national estimates or whether you use the Bar Association, the state bars estimates. It's a very small proportion of those that get any kind of expert legal assistance. So if you think about justice problems from the perspective of the public, there's the part that current service providers see. That's a minority. It's somewhere between 11 and 24%, depending on how we count it. And then there's the rest of the activity, which is real people with real justice problems who are not making it up to the surface to touch legal services providers of any kind. Now, one of the most important reasons that this happens is that people don't recognize the legal aspects of their own problems. And in the California report, they call this the knowledge gap. So one way to see this is to do something that I and others have done, which is when somebody reports an issue, so my employer's not paying me overtime, or I'm 3 months behind on my rent, you say, okay, you told us you have this situation in your life. What kind of issue is this? Or what kind of situation is this? Is it a legal problem? Is it a moral problem? Is it a personal problem? Is it a bureaucratic problem? Is it a criminal problem? Is it bad luck? Is it a part of life? And you see something really striking when you do this in the US. So the most common way that Americans describe their justice problems is as stuff that just happens. So it's either bad luck, this is the kind of stuff that happens to everybody and now it's happening to me, or it's part of God's plan, which is an even more powerful way of thinking about stuff that just happens than that it's luck, right? This is supposed to happen to me. And the way people frame their problems turns out to be really important in shaping whether they do anything at all and the kind of thing that they do. And so you can imagine that thinking that this is just my lot in life is certainly not going to lead me to file a lawsuit, and it may lead me to do nothing at all. There's another chunk of problems that people describe in a way that suggests that they think maybe somebody should do something about them, but it's not a third party out there. So these are our problems. They're family problems, they're my community's problems, they're a private problem. We're going to work on this, but we're not necessarily going to reach outside ourselves for help. And then it's really a minority of justice issues that people recognize the legal aspects of. And as I said earlier, the ones that recognize the legal aspects of are the ones that force them into court or that lawyers tend to provide services for. And lawyers don't tend to provide services for everything, as we know. So why would new kinds of services make a difference in how people think about their problems and what they do about them? So I want to just go through sort of step back for a second. So one thing is to think about what's new. So what is happening in the US and what's being contemplated in the US. And one thing that's new are different kinds of authorized legal services providers. So these would be things and people who are not lawyers who are practicing law in one way or another. And the other thing that's being considered are new ways of financing and organizing the production of legal services. So sometimes this is called alternative business structures, or ABS. So some of this is multidisciplinary practice. And if you think about the personal client world, that could be a doctor and a social worker and a lawyer setting up together to kind of wrap around the problems that the populations they serve have, for example. It also permits, so Tesco is a big grocery store company in the UK, which has had ABS for a long time. And they do legal services, and it's called Tesco law. So in the US, it would be like Walmart law. So between the nail salon and the eye care place, there would be a little law office, and you could get legal services there. So these kinds of new rules about financing could permit that kind of innovation. Now, why are we considering this? Why instead of doing exactly the same thing that we've been doing for 60 years that hasn't worked, would we consider change? Well, one reason is the experience of other jurisdictions. So since 2001 in Australia and 2007 in England and Wales, they've had non-lawyer ownership, and the world has not ended. It seems, nor has the legal profession. The legal professions have grown. They haven't become extremely concentrated. Things have been okay. This has been permitted in the United States and DC for decades, so that basically lobbyists can be part of law firms and partners in law firms and collect money from the work of law firms. And then not only in the UK and other foreign jurisdictions, but in the United States, non-lawyers have been authorized to provide legal services for decades. And they've performed them quite well, as I'll show you here in a moment. So if you want to think about the kinds of stuff we're thinking about in the United States, or that's already being done in the United States, we could think about traditional lawyer practice as kind of the anchor, and then we could move away from it in different ways. So if you think about what a traditional lawyer can do, they can represent you they have rights of appearance, but they can also represent you to the other side. They can be you in negotiating with the other side. They can enact things on your behalf. They can file motions. They can complete documents. They can give you legal advice. So they can say, given the law that applies to the specific facts of your situation, here's what I think you should do and here's why. They have privilege, so they cannot be, if you give information to them that you don't share with anyone else, they cannot be compelled to share that information outside the relationship they have with you. They can give you legal information. And then an really interesting thing about the way we do lawyers in the United States is once they complete their training, which in many states is law school, but in California also includes training in a law office. And then are licensed and passed the bar, we stamp omnicompetent right on their forehead. So as soon as you are licensed to practice law, you can help individual people get divorced, defend them in a capital murder trial, or do a multi-billion-dollar merger, right? You are empowered by the rules to do all of those things. If you look at the new roles that are rolling out in the US or that have existed in some jurisdictions for a while, what you see is they take pieces of that and pair it off. So none of them claim to do everything. None of them play the omnicompetent card. They say they're good at they're one thing or a group of things. And then they take parts of those capabilities and empower different kinds of people and things to do them. So you see computer programs. This is one from New York City called Just Fix, and she's holding up a picture of a dead rat, and that's part of a web app that helps you write a letter of complaint to your landlord that includes date stamped, time stamped, geolocated pictures that show that these are the conditions in the apartment that that guy is responsible for. And it writes a very formal letter that cites housing code and sends it off as a certified letter for free. They'll also help you file a lawsuit against your landlord for conditions violation. It's helping you enact legal stuff. It's providing legal information. It's kind of edging up against advice a little bit. The kinds of regulatory changes that are being explored in some parts of the country would let this sort of be more active in terms of its shaping your options and you're thinking about them. A number of states, so this in Utah, it's called a licensed paralegal practitioner. You know, you have people who are empowered in specific areas, say debt, family, eviction, to do some or all of what lawyers do in those areas. The restrictions right now, I don't know that any of these folks can appear in court, but I think certainly in Utah, they're contemplating letting them appear in different kinds of formal hearing forums, but they can do a lot of what a lawyer can do in a narrow frame of competence. Including having privilege because they're licensed legal professionals in a way that a court navigator or somebody like that is not. Then you have around the country a set of legal information sources that also include the ability to kind of have a smart TurboTax style form filling out exercise. So technically these things provide legal information, but they will also help you file fill out a parenting plan or write an answer to your landlord or something like that. And then you have a range of roles that are often court-based. They provide legal information about process. They can sometimes accompany you through process in housing or in debt. So that's a picture of a New York City court navigator. That's a college student who was trained and then was a volunteer in the Brooklyn housing courts to help people facing eviction cases who didn't have attorneys put their paperwork together, understand what the next steps were, and so on. So there are a range of these different models around the country. The current rules mean that unless they're certificated state authorized programs, they can't give legal advice. And that turns out to be a big issue. Because what consumers would like oftentimes is legal advice. So we have some information about consumer demand, and it suggests that if you ask people what they want, they're actually more likely to say what they want is to understand their situation and how to act on it rather than to empower someone else to act on their behalf. People are happy to use non-lawyer providers when they exist. And it turns out that if you compare places where there are few alternatives to places where there are lots of alternatives, having more alternatives encourages people to act. And I'm going to gallop through this as fast as I can. So if you go to legal aid websites that have live chat and you look at what people are asking for and you code those queries are almost always answered by non-lawyers. Even when they're answered by lawyers, it's not a lawyer-client relationship, so you can't give advice, you can just give information. But what you can get is different from what people are looking for. And so if you look at these legal aid live chats and you compare, say, an urban state, we won't say what it is, to a rural state, we won't say what it is, people are always more likely to be asking for advice than for an actual attorney. Now, there are a lot of factors that shape what they're asking for, the kinds of problems that come through, the sort of legal culture of the state, but they're always more likely to be asking for advice. What is the situation? What should I do about it? Than have somebody to take it over for them. And then if you go back to those justiciable problem surveys where people have a problem and then they go get some help and you say, okay, when you went to the city agency for help, what did you want? Or when you went to a family member for help, what did you want? What you see again is that people are most often looking for advice. So of all attempts to get help from anybody, half the time what consumers are looking for is legal advice. What is my situation? How can I handle it? What are the next steps? If you narrow that down to people seeking help from formal sources, so this could be a city agency or a legal aid office or a private lawyer, 63% of the time people are looking for legal advice. They're much less likely to want someone to refer them somewhere else, and they're also less likely to be looking for someone to represent them, either in a formal hearing or to the other side. The other thing that we know is that in the United States, we've had non-lawyers actually representing people in a range of forums. Many of them are federal, or they're federal but delegated to the administration by states for over 60 years. And people use these. There is consumer demand for them, right? So in Wisconsin, there was over a fifth of unemployment compensation appeals. It was almost 40% of tax appeals. Nationally, it's over a fifth of SSDI appeals. And of course, we know that there are lots of people accredited reps who work in federal immigration matters, including immigration courts around the country. The last point here is that if you compare contexts where people have lots of choices to where people have few choices, you see that having lots of choices encourages people to take action on their problems. So let's imagine a place, it won't be hard for you to imagine this, where there's very restricted legal aid. So we give legal aid to only a small portion of the population and we don't fund it very well. And then lawyers have a super strong monopoly on the practice of law, which means if you have a legal problem and you need actual legal help, there aren't any other places to go. So let's think about a place like that. And then let's think about a different place, a place where there's really expansive legal aid. So at the time when this study was done, 60% of the population was eligible for Judicare, which is just like Medicare. The government gives you a voucher to pay a private lawyer for a legal service. You pick the lawyer among those that accept Judicare, just like with Medicare. But at the same time, you have all this legal aid, but you also have many non-lawyer alternatives because there are many different kinds of actors who can provide legal advice. There's no restriction on who can provide legal advice. So then you can look at how people handle money and housing problems in those two different contexts. So the same kinds of problems, two different sets of service providers. So of course the restricted legal aid with a strong lawyer monopoly would be where we live right now. And if you look at how people handle money and housing problems, you see that they do nothing, about a quarter of them. They take only 8% to non-legal third parties because there aren't any. They go to lawyers a quarter of the time. And then the most common thing that they do is handle things on their own. Now let's go to an environment where law is free or heavily subsidized for 60% of the group that we're about to look at. But then there are also all these non-lawyer alternatives. Well, okay, hardly anybody does nothing. So it goes from a quarter of people doing nothing or a quarter of problems being resolved by doing nothing or handled by doing nothing to 5% of problems being handled by doing nothing. We go from 8% of problems going to non-legal third parties to 36% of problems going to non-legal third parties because they're there and they're empowered to do useful things and people want them to do those useful things. And we see that only 10% of problems go to lawyers, even when lawyers are free. And again, the most common thing that people do is handle problems on their own. So there's clearly consumer demand for a greater variety of services than we offer here in most jurisdictions in the US. Now, the third thing is, so what if consumers want services if those services aren't good, right? So consumer protection is an important reason that we regulate the practice of law. If you look at a range of research, and I'm only going to show one study because it's quite expansive, but I'm happy to share others if people are interested. Specialized non-lawyers consistently do as well or better than traditional attorneys. But remember, specialized, that's a key point. So this is a study that comes from the UK when they were thinking about reforming their legal aid system and giving less money to lawyers and promoting more other kinds of services. And it's what's great about this study is it's based on peer review of work files. So people who are experts in immigration or personal injury or debt independently assess the work of lawyer and non-lawyer providers, and they rank it as competent or incompetent or really excellent. And you see some very interesting things. So the first thing you see, and this is true of professional work generally, is everybody makes mistakes. So across the cases that were in this study, both lawyers and non-lawyers screwed up 25% of the time. If everybody's screwing up 25% of the time, it means everybody's getting it right 75% of the time. and neither lawyers nor non-lawyers were more likely to get it right. The thing that's really quite striking, though, is who was more likely to knock it out of the park? Well, it's not the solicitors, right? So the solicitors, the non-lawyers were about 8 times more likely to have their work rated as excellent as the lawyers were. This is one of many studies that shows that it's perfectly possible for specialized non-lawyer assistants of different types to provide legal work that's as good or sometimes better than traditional legal professionals. There are a lot of opportunities here in thinking about these different ways of permitting new kinds of services. One is providing consumers greater choices so that they can get what they want, right? Another is that it sort of relaxing some of the traditional rules allows services to be designed around clients, not around the preconceptions of the different constituent professions. If this drives down cost, or if it makes things more accessible for other kinds of reasons, because say it's at Walmart and not 50 miles away in a city, that's going to expand access. There are new sources of revenue investment to do these kinds of things. And this is a more efficient model of regulation because it's focused on consumer protection directly. For example, if you think about the Utah model, rather than all this sort of upfront stuff and then letting them run and hoping consumers complain. So there are a lot of really great chances here to expand access to justice in ways that are safe. And we have a good evidence base to help us think about how to do that. So I thank you for your attention, which has been very patient, and I look forward to the rest of the conversation. And you should feel free to reach out to me for any of the sources or resources or any questions or further conversation after this today. Thank you.
Great, thank you. We've got 2 working group members with hands up. Carolyn, go ahead.
Okay, good morning. Can everybody hear me this time?
Yes.
Okay, I see nodding heads. I had the, in honor of I think our speaker is from the Midwest, as am I. So I had the University of Michigan Law Library up there. It looks like Hogwarts or a cathedral, and always, what's that? Where's that? Anyway, I took it down. It's a little distracting. Okay, so thank you for that, and I know you've done just an amazing amount of work on this subject, so I really do appreciate the scholarship that you've put into this. Just a couple, well, and I have a number of questions, so I don't know if I'll go first and let everybody roll around, wrap it around like that. I had one of the things that got me involved and interested in this group was that I'm a solo attorney right now, but I've worked for big firms in the past. And I really have enjoyed training paralegals and young attorneys to, become better. And usually they get stolen by partners because they're like, oh, she's really good. You don't want to take her, you somebody else. But one of the things that I've realized is that women are paralegals. 80% of women are paralegals since that term became invented. So if we create, and I wrote an article in the Daily Journal about this, if we create this new position, how do we ensure that we are not simply taking women and people of color who would normally have gone to law school and saying, okay, we're going to give you a little bit more authority, but this is cheaper than going to law school, so do this anyway. How do we prevent that and make sure we have a real gender even equality-based program for people to get into?
I think that's a great question because it's part of a bigger issue, which is that this is a big public institution that mediates people's access to their own laws. And so you want that institution to take advantage of all of the talent that's available to make that possible. And you want it to look, insofar as it can, like the people that it serves. So I think that's a really important question. I think you would need to do it from 2 sides. So one is, why does legal education cost $150,000, right? I mean, that's an important reason that many people are kept out of it. And that's not something that I think this group can solve. But I think it's important to remember that as part of the context. Then I think you need to think about outreach for entry into this group. So the triple LTs in Washington State, who got sunset, there wasn't it was a new idea and no jurisdiction had done something quite like that before. So I'm not criticizing the way it was implemented, but there was not a great deal of outreach to think about how can we draw in people around the state? How can we draw in a diverse constituency to do this? And it had practice requirements, and that made it easy for existing paralegals to sort of take this jump up because they had to have 1,500 hours of supervised practice. Well, of course, if all the existing paralegals are already women anyways, then that's going to be who's going to take the jump up. And so I think some kind of intentional outreach through community colleges, which is where some of this education is going to take place, through other kinds of channels, so that you're encouraging people who probably can't afford law school, and that's its own different issue, to enter into this other opportunity to serve the public through legal practice. And I think another thing to think about is, why does this have to be the end? So for some people, this might be the end of their journey into practice, and that's great, but it could also be a first step. And so what are the ways that you can design pathways so that some of that great talent can make it into the traditional practicing bar?
No, thank you. That's it. I've had several secretary paralegals that have gone on to law school, and it's been just great to watch. So I'll just let everybody else go next, and then I'll come back around if anything that I wanted to hear didn't get asked.
Okay, Steve Fleischman.
Professor Sandifer, thank you very much for coming today. So you know, our group is only looking at the issue of licensing paraprofessionals. We are, as I understand it, another state bar group is looking at the ownership of law firms by non-lawyers, technology, those type of issues. So my question is specific as it relates to people with claims where there's recovery of statutory attorney's fees. So in California, in my view, one way the legislature has acted to close the justice gap is to provide that the prevailing party in a case can recover their attorney's fees, because that gives economic incentive to lawyers to take the case. And our courts in California have, in many cases, particularly in employment, interpreted those statutes so that only the plaintiff can recover attorney's fees, and only in limited circumstances can a prevailing defendant recover them. And, you know, my experience is there's no shortage of attorneys out there willing to take those type of cases. And there's tons of advertising in California. And my view on lawyer advertising is people wouldn't pay for it if it didn't work. So my question is, where you have those situations where fees are recoverable from the other side, what empirical evidence is there that there aren't enough lawyers to represent the consumers, and that the consumers can't find somebody to represent them within the existing system?
Great question. There are two pieces of it. So one goes back to the issue that people with actionable justice problems don't recognize the legal aspects of them, so they're not going to the fee shifting attorneys anyways, right? So that's one issue, and that is separate from the fee shifting issue. Fee shifting is an interesting and insofar as we know, sorry about the coughing dog in the background, insofar as we know, kind of complicated model. In Massachusetts, in landlord-tenant law, you can fee shift. And there's a housing judge there who's really interested in this, and he actually had a practice where he helped indigent tenants by using fee shifting rules to get private practice, market-based legal services. But he's been looking at, he's a judge, so he's got access to court records. Almost nobody uses it, right? It's there, but it is not used. So I don't know, that's a lawyer problem. That's a question about why lawyers choose to use these remedies or not. But there's at least in that context, the problem isn't that people aren't seeking the fee shifting, it's that lawyers aren't seeking the fee shifting, and we might speculate about why. But the other thing to think about is, if I'm paying you up front to do legal work for me, there's no risk in taking my case based on anything about me or the case, because I'm just going to pay you. But once you make it, fee shifting is a kind of contingency. And what we see is that when that comes into play, there's a whole set of cases that go off the table because lawyers judge them as not financially viable, which is different from being not legally actionable, right? So let's think about personal injury. If the issue is my injury is worth $1,000, who cares? I'm still injured, right? I should still be made whole. But there's no incentive to enter into a formal legal process and have an attorney eat that plus more in the process of pursuing that claim. And so that becomes an issue when you think about fee shifting, where lawyers are not necessarily going to take cases because they are meritorious. They're going to take cases because they're viable. And so I absolutely agree with you that that can be a way in which some kinds of cases that are currently kept out could make it in, but they would be in the tiny minority of cases that get taken to lawyers to begin with anyways. So again, I think it's certainly part of it, but it's definitely not all of it or even most of it.
Well, then, if I could just follow up on the first part of your answer, why would adding, I'm just making a number up, why would adding 5,000 paraprofessionals in California change the number of consumers with problems who don't go seek help? I mean, that seems to me to be a sort of disconnect, which is, according to the California Justice Gap study, 2/3 of people with problems don't even try to find a lawyer. So why would adding non-lawyers change that dynamic? And you called it a knowledge gap. I call it an education gap. I think we're talking about the same thing. I mean, go ahead.
So I would make two observations. One, I would take you back to that study that compared a context where there were many non-lawyer alternatives to a context where you had choice between lawyers and nothing. People are much more likely to do nothing when their choice is lawyers or nothing than they are in a context where they have greater choice, right? So because greater choice means a lot of things. It means, where is this person? It means, how can I reach this person? It means, is this person organized around my community group? Is this person organized around the kind of problem that I have? There are lots of reasons that it makes it more accessible.
But
the other thing is,
go ahead.
Paralegals are, insofar as we know, cheaper than attorneys. And at least when Tom Clark and I studied the triple LTs, one of the things that consumers really appreciated about them was twofold. One was, many of them worked for flat fees. So they said upfront, here's what I will do, and this is exactly how much it's going to cost you. Lawyers are less likely to do that. And the other is, they were cheaper. They were a little bit more than having a paralegal, than the paralegal was making in an hourly rate inside a firm. And they often were embedded in firms. And so if they got to a point where they weren't allowed to appear in court at that point, they got to a point where somebody needed a court appearance, or where the nature of the substantive legal work was outside of their expertise. If they were in a firm, they would unbundle that off to one of the firm attorneys. And so actually having those folks around increased the capacity of the firm in two ways. One, it could do more differentiated legal work, but it could also reach markets that it wasn't going to get without that lower cost provider. And then that benefited not just the lower cost provider, but the other attorneys in the firm who were getting this unbundled legal work that the triple LTs couldn't handle.
I don't have that slide up in front of me, but as I recall that slide you referenced, in the second alternative, there was greater government sponsorship of legal aid programs or outright payment of fees. And I would think that probably had a lot to do with why there were fewer people not doing anything then.
Actually, what it showed was that people were much less likely to go to lawyers, even when lawyers were free, when they had alternatives.
Okay. Thank you. Leah, who's next?
Amos.
Hi, good morning. I had a question. One of the ways this working group is trying to use data is to identify practice areas and tasks within practice areas that might benefit from this type of program. I was wondering if you have any suggestions. If you were tasked with identifying practice areas for such a program, where would you look, and what might be helpful for this working group to assess for identifying practice areas and tasks within practice areas?
I think that's a great question. I think one way to frame that is, what do you envision the capacities of this role being? So there are some things where, one of the things that they ran into with the triple LTs who could not appear in court was that they couldn't represent at all. So they couldn't negotiate. They couldn't communicate with the other side independent of their client, which turns out to be really logistically complicated. So they had to change the rules to make that possible. So one thing is sort of, what are the actions that need to take place in whatever kind of problem you're going to put this kind of role, and can that person do enough of those actions to make it workable? So, so for family law, it's not necessarily the case that you need to be able to stand up perhaps for somebody, but you need to be able to communicate with their soon to be ex-spouse or the person they're negotiating childcare with or whatever. I think another thing I would encourage this group to think about, if you look at the research on when non-lawyer humans, let's set aside computer programs, non-lawyer humans can do well. They do well when they specialize in some, not necessarily just one kind of thing, but a defined set of things. And when they're in the simpler parts of that. So if you compare, for example, there was another study on will writers in the UK. So non-lawyer will writing companies will send a will writer to your home and they'll sit down with you and talk about what you want and write your will. And if you look at simple estates or simple probate situations, the will writers do better than the solicitors. But if you look at complex situations, the solicitors do better than the will writers. So you want to think about ways to have capacities that are reasonable given the training and experience of the specialized provider and off-ramps. So to give you a different example, there's a great program called Citizenship Works that some of you may be familiar with. It's on the web. You go on, you're basically, it's like, let us help you regularize your status in the US and then apply for citizenship if you're eligible. And there are various things that, particularly in this moment in history, make you not only not eligible to regularize your status, but at risk of really serious problems. And so that program really quickly off-ramps you and says, okay, given what you've described, you really need to talk to an attorney, and here's how you might connect with an attorney. And so you also want to think about, you can train the provider to understand that this is beyond my competence. But you also want to have some way to, the service to the consumer is to off-ramp them to someone who has the right competence. And so maybe that's embedding it in a legal aid agency, maybe it's embedding it in a law firm, or maybe it's creating relationships so that if I'm my own paralegal, my independent paralegal, I have existing referral relationships or some mechanism that lets me send that person to somebody who can help them.
Are you good, Amos?
Yeah, thank you.
Okay. Julia.
Hi, Professor. Thank you very much for being here. I had a kind of a follow-up question on what Amos just asked.
Yes, I get it.
When you talked about in your presentation, first of all, a satisfaction level between receiving service in the United States with some criteria, the data, and then England and Wales. One thing I noticed was that the USA data seemed to be from 1992. Could that be correct? Do we not have any newer data than 1992?
Well, at the time when I wrote that paper, which was in 2009, the answer to that question was no.
Okay.
So when is the last time the federal government launched a civil justice survey? That would be never.
Got it. So I was just, so that from because I'm also a professor in community college, I was just interested in that. The data, I would have assumed that was the problem. There's no newer data collected by anyone since.
Well, the World Justice Project did a 2018 web survey of Americans. That is, it's not as representative as you would like. It's older. It's too old and too white to look like the nation, but it does include younger people and people of color. So the best thing that we have nationally, there are two. So the LSC's Justice Gap Study, which is only poor people, from 2017. And then if you really want, that 1992 study was only low and moderate income people. If you want to go back to a comprehensive study that includes that's nationally representative, it includes all income levels, you'd have to go back to about 1979.
Okay, well, the other follow-up question I had, then you were making some distinction between giving information versus giving advice. And sometimes that can be a very gray area. Did you ask questions? How did you formulate whether someone is just receiving information in a neutral way versus defining it as advice. Normally, I'm a paralegal professor, and one of the rules of thumb we talk about is if you're being asked to give a legal opinion, what I say is if you're having to tell them about their legal rights or their duties, you're probably giving them legal advice. Don't do it.
Yeah. So this was, that survey wasn't asking what you got. It was asking what you wanted.
Okay.
And so it said, you know, I want someone to tell me what my options are, or I want someone to tell me what my legal standing is in this situation. So there were some possibilities that were apply the law to the facts and tell me what I can do. And there are some possibilities that were like, I want moral support, or I want you to send me to somebody who can take this problem over for me. But we don't know what they actually got. We only know, well, we do, but we only know what we know what they think they got. but that question is about was what they wanted when they went out looking for help.
Okay, thank you very much.
Sharon.
Thank you. Thank you, Professor Sandifer, for speaking with us today. Your presentation has been very, very interesting. I come from legal aid. I have two questions for you. My first question is, who does this serve? I know that legal aid serves a range of folks, including those who are extremely low income. In looking at paraprofessionals in other states, they charge often at a lower rate than attorneys, but sometimes not much. And regardless, they still charge. I am most interested in pathways for those who are extremely low income, who either have not been able to obtain services from legal aid, but really can't afford to pay anything at all, or those who just don't recognize their issue as a legal problem. Do you have any ideas on pathways for those folks?
That's a great question. And since most of these models, especially the independent paralegal models, are new, we don't have a lot of data about what happens in the US context. I think I would make two observations. So you're absolutely right. Any market-based service charges a fee. That's the nature of being a market-based service. One thing that legal aid agencies could do, and this is something I would encourage them to consider, is hiring some of these people to provide some services, because they are not as expensive, either as employees or as service providers, as traditional lawyers. And the evidence is pretty clear that there's some set of problems that people are going to come in with that are perfectly within the competence of these kinds of providers. And so legal aid, for the same amount of money, could expand its capacities by incorporating some of this kind of stuff into its organizations. I think a second question, though, is about scaling. And I want to preface this with a disclosure. So I would like to live in a Swedish-style social welfare state. I really would, right? I don't care who you are. I don't care whether you deserve it or if you're nice. Like, you should have a decent life because you're a person and you're part of society. That's not where we live. And we live in a place that has scaled back public services on everything for decades. And even if everything goes very differently in the next election, I don't see that changing in a big way. So think about the Great Recession as a wonderful opportunity to have a New Deal. Didn't happen, right? I mean, there are lots of forces that are making our government budgets look the way they are, our economic policies look the way they do. And so if you want to scale, there is not an infinite and magical source of subsidy to scale up to the need, even for the very low income population. So if we're not going to have that, then the question is, what can we have in this world where we are fated to live? And I think one thing we can have is nonprofit firms that come in and say, you know what, we're going to have a sliding scale. And maybe there are some people who will help for free, and maybe there's some people who will charge just a little bit, and there's some people who will charge a full amount. And that's going to allow us to make a living and actually produce the service, but expand it to many more people than we'll ever get to if we rely on free to the point of service, totally subsidized stuff. And I say that with the disclosure like that's the world I want to live in. I want to live in the world where this is a matter of right and an entitlement, like it actually comes to you. Not just you're eligible for it, but like you actually get it. But I just don't see that happening anytime before I'm dead. So my mission is to try to think about how can we get closer to that, given the opportunities that we have in this moment.
Thank you. My other question is, do you have any recommendations about the necessary consumer protections, or can you point us to some research about such protections?
So I think that's a great question. So the model that California is taking with the paralegals is to say, I think, it's parallel to what we do with lawyers. So we train you and we certify you up front, and then we let you go. And the only monitoring that happens on you after that is consumer complaints. You could think about a very different model which is like Utah's model. So you have an experimental regulatory space where you say, okay, you're in and you can do this thing that you've been approved to do that's not traditional, but you're going to have to provide us data on a monthly or quarterly basis about these things that index consumer protection. And if there's a problem, we're going to come in and make you fix it or stop you entirely. And so you might think about that instead of sort of trying to do everything up front, given that we don't know really how a lot of this works, having a more engaged, persistent regulatory strategy that's about actually identifying harms and then acting on those harms rather than hoping you can prevent all of them. Because we know lawyers make mistakes, and we know that everybody else is going to make mistakes too. And so is it better to just like cross our fingers and hope they don't, or to be more engaged on the behalf of the consumer while the service is being provided? So I would just encourage this group to kind of think about, if you create a new role and you let it loose in the wild, how do you want to monitor how that's going? Are there ways that you could do that so that you can sort of track whether it's meeting the goals of the program or it isn't, and then make corrections?
And for Reba and Amos, who are on the regulation subcommittee, Professor Sandifer is talking about proactive regulation, which we have not quite yet touched upon in that group, but just to tie it back to, I think we sent you a paper on that, and certainly it's something we will be discussing. Claudia.
Hello, Professor. Thank you. Thank you for sharing that really great presentation. I am not a lawyer or work for anyone in law. I'm just a consumer, right? I'm an artist, I'm a professional, I'm in education. So for me, I think I want to speak a little bit to what Mr. Fleischman was asking about earlier, just affordability, accessibility, those kinds of things. I know that as a consumer, as someone who has been speaking about everything that's going on in these meetings with other consumers, what I keep hearing from people is that there's a lot of mystical kind of perceptions about the law system itself. People do not understand the world of law. People are scared of lawyers. They fear lawyers. And this is one of the main reasons that we do not seek legal help. So what I've heard from people is that having a sort of a paraprofessional person that is licensed, that is trained, that is supported by state board would actually help them to seek some help, because many times we do not ask for help from the lawyers because a lawyer is someone that sues you, that's against you, that's not a friend, not an ally. So I've also heard a lot from the folk in the committee that there seems to be sort of some apprehension, some resistance to the development or the fruition of this process because of maybe a perceived sense of competition. And I would really like for the group to move forward and think of it more as not as a competition or as a group of people that will take business away from the lawyers, but rather as allies, as assets, right? It would be wonderful if they could possibly be embedded into with the law firms, have them not necessarily as separate entities, but maybe in addition to, right? So I really appreciate all of the information that you provided, and don't really know how to help move this forward. But I do know that the people, at least the people that I've communicated with, want this to happen. They do see it as an interesting opportunity. That's something that they would want to participate in. And knowing that there are more options would help them to actually seek more support, more help. And maybe as a result of partaking with some of these potential future paraprofessionals, they would then seek further legal representation because they would understand that they would probably benefit more from an actual lawyer. So those are some of the things that I wanted to share with you all. Not really questions, but rather my perspective upon some of the comments that I've heard from the folks.
Thank you, Claudia.
Thank you.
I don't know, Professor Sandifer, if you want to respond to any of it. I think it does tie to a lot of the points you've made as well. Really.
I mean, I think it's first of all, wonderful, Claudia, that you're on this committee and that this perspective is available to this group as it thinks this through. You know, sometimes when I talk about these opportunities to like small private practice lawyers, I say, listen, this iceberg is a giant untapped market.
Yeah.
And some of it is there for traditional lawyers, and some of it is probably more appropriate for new kinds of providers. But there's a lot of pie here. It's going to be a long time before you need to fight over the slices. So I think that's a really important thing to keep in mind, thinking about what you want to do next.
All right, Ira.
Yeah, I'm just getting over that very clear comment. People are afraid of lawyers, and it hadn't occurred to me before. I'm a lawyer.
Oh yes, yes.
That's
like, don't mess with the lawyers.
Claudia, that's for me. But true, I'm sure. Well, Professor, I have a question about some people have asked me about what they think may be a problem with the paraprofessional program if it gets started. And I wonder if you have any experience or knowledge about this. The problem is this, or the potential problem, that I'll call it big business gets involved in providing paraprofessionals, and they have programs where people pay to subscribe, if you will, like something like legal insurance, and they pay money and they don't get much for it. That's the problem that's been described to me. Do you have any knowledge about such things? Like, for instance, with the Tesco thing in Great Britain.
So there haven't been wide scale. I mean, what you're describing is kind of fraud, right? So I say I'm going to help you with getting your driver's license back, and I take your money and I don't, or something like that. They haven't had big issues with that.
It's a little. It's not I see what you're saying. That is kind of fraud, but it's more like big business fraud, where like if, say, you're buying an insurance policy, you're buying a warranty for the refrigerator you bought, and you're paying a lot for the warranty or insurance policy, and if you really got to look at it real carefully, you're not buying much of anything. It's more like that.
I understand what you're saying. So Tesco law, for example, doesn't rely on those kinds of subscriptions. What you would see in the US that's something like that is something like Rocket Lawyer, right? So you buy the premium membership in Rocket Lawyer, and then you get a certain amount of legal advice and document preparation and so on. And certainly Rocket Lawyer gets complaints, but there's no sense that it is, I'm going to use the S word, screwing people all the time out of their fees. I think that the thing, that's one way to think about whether a company could come in, Walmart Paralegal Services Incorporated, has to do with a different set of rules that I think this group is not considering, but I think should think about, right? You're not in charge of, but should keep in mind. And this is related to your question, which is the ABS rules. So who can employ legal services providers to provide direct service to clients who are not the employer? And how can you prevent, how much do you want to let the market decide whether the service is a good service or not, right? So, and I think that's a really important question. And so I would encourage the group to think about what kind of information could you be getting as regulators that would show you that that was happening? And then you could stop it. As I say, I haven't heard of that being a widespread problem in the UK or in the US. I also think in the US, it will be interesting to see. So if these things happen, the consumer market will change, the set of options will change. But Americans have never been interested in legal insurance. You know, the only people who have legal insurance are people who have really awesome union benefits. And so it's just not been a product that most people have been willing to adopt. So sort of whether there's that opportunity to exploit people is one issue. But I think you're absolutely right to think about, as those two rules change, what would be the indicators that things were going south? How could you see that before lots of consumers had to complain? And then, you know, who would be the regulator that would step in? So would it be the bar? Would it be the attorney general? Would it be somebody else? I mean, I think it's great to be sort of imagining that particular possibility.
Thanks.
Stephen.
Hi, just a follow up that I forgot earlier. It's mostly a two-part question and then a comment for you. Of the existing states that have instituted paraprofessional programs, regardless of the exact title, do any of them allow paraprofessionals to handle jury trials?
To my knowledge, no.
Okay, then the follow-up to that is, what court appearances, if any, are they allowed to make? We heard from a Washington paraprofessional who described it as she can sit at counsel table and answer factual questions from the court, but not make legal arguments. We heard from a Utah Supreme Court justice that they're only allowed to make appearances in, I think he said small claims court, which in California means not a jury trial. I'm not sure about Arizona, other than it's limited to their limited jurisdiction court, which I don't know if limited jurisdiction in California means one thing, it may mean something different in Arizona. So please educate us.
So to my knowledge, there is no U.S. jurisdiction that allows paralegals to practice in district courts, basically, in like normal courts. They can go into small claims in Utah because anybody can go into small claims in Utah. So you don't have to change a court rule to have that happen. Utah is contemplating letting them into more traditional court environments where people would have attorneys on the other side and on a regular basis. But to my knowledge, that has not happened yet.
Okay, and then just a comment for you. You mentioned flat fees. My experience is flat fees are becoming much more common than they used to be. There's no question for you or anything, just a comment for you.
Well, and for those of you who have small practices, consumers love flat fees. Consumers, so there's some great research about what consumers want, and they want transparency about cost. They want transparency about process. They want frequent contact and updates on their matters. And so whether you're a lawyer or a paralegal or some other kind of provider, being able to do those things is highly desired by consumers.
Not just consumers, I would add to that. I'm on the other side, and lots of non-consumers want flat fees. Thank you.
All right, Leah, am I next?
Yep, you are, Carolyn.
Okay, great. Okay, so and how much more time do we have?
We have 45 minutes, I believe.
Okay, all right, because we have an expert here, and I want to, I've got lots of things to talk about, and I want to get back to kind of your specialties and things. But before, I also wanted to welcome Claudia and thank you for your thoughts, and I can't wait to see more of your participation. I am sorry, I am on the other side. I represent people with injuries, plaintiffs, small artists, musicians, little guys, and I am so sorry that you're afraid of us. I know there are lots of warriors for justice out there, And so I'm hoping through these hearings, I can help you, convince you that there are good people out there fighting really hard for people with kinds of problems. But anyway, and I have some substantive things, but first of all, do you have a bibliography, Professor, that we can get? Because there was a lot of things in your slides, and I pulled a lot of things from we have a great collection of materials, but is there something you could send us?
Absolutely, I'd be happy to share that with, should I share that with Leah or?
Yeah, go ahead and we'll get it out to her.
But then, okay, so back to the studies, and to get really boring and wonky. I know there's the 2017 study that there's California by the Legal Services Corp. There's the 2019 Justice Gap study. I think I've seen there's one or two of those World Justice Gap studies, but I don't know that they drill down into the United States very much. And you're not the study person. You're not doing the interviewing yourself. Is that right?
It depends. So to go back to the World Justice Project, they have one for 2019. So they did 101 countries, sorry, 2018, 101 countries in 2017 and 2018. And the United States is one of them. And it follows that same basic format. Ask people about defined problems, ask them what they do about them, ask them if they were able to find help, ask them if they experienced, a knock-on hardship as a result, ask them if they had a financial loss, that kind of thing. And it's quite interesting to compare. I mean, jurisdictions vary in all kinds of things, but it's quite interesting to compare those profiles across the parts of the world where we know. And then for the research that I've done myself, survey research is typically, now a lot of it's done online. The one that I was talking about was a door-to-door survey in a medium-sized Midwestern city where survey takers go to the door and they offer you an incentive to participate in the survey, and you get a representative sample of the community and answer the questions. There's other parts of that I did myself, because you can't survey a representative sample of a community as a staff of one. The census uses thousands of people, right? I mean, it's a very, very common model. But some of the other work that I've done involves either focus groups with people who are grouped based on their income level. So people who would be LSC eligible versus people who are low moderate income versus people who are high moderate income. And then also interviews with people who were parts of that survey to follow up with them about how their situations were going. And it was really those first focus groups, which I did a bazillion years ago when I was first starting down this road, that sensitized me to a couple of things. So I had a very naive idea that people were kind of fatalistic and they were like, oh, I can't do anything about my problems. Oh my gosh. And so I'm going to do nothing. But in fact, people are incredibly efficacious. They don't necessarily know or have access to the most effective sources of help, but they do stuff. And the other thing is that so many of these problems emerge in relationships of different kinds. So relationships with your employer, relationship with the person at the Social Security office, relationship with your neighbor, relationship with your ex-spouse. And we're very social. And so we experience those problems as things that are part of that relationship first. And then we figure out different ways to solve it. So if you have somebody who's experiencing wage theft and you say, what do you think is going on there? They won't say, I think I'm experiencing wage theft and this violates blah, blah, blah. They'll say, my employer is a jerk. Right? And so I think that was a very powerful, I'm very glad that I did that stuff myself, because people's experience is so different from either the law as written or the law as practiced, I think in many instances, which is why you need consumers on groups like this. I mean, that perspective is really illuminating about what's going on and how you might connect with it. And you're not going to connect with it by running around saying free legal help. You're going to connect with it by saying, is your employer not paying you overtime? Oh my gosh, there's help for that.
So should we just give up on the courts? Are we saying that, our courts in the United States, it's just no one's ever going to give them any more money, forget about it. We just have to move on and find other solutions.
Well, this group's job isn't to fix the courts. But no, of course not. I mean, courts are they're the place of last resort for binding resolution to all kinds of problems and for people who are in certain kinds of extreme situations. But I think that's a problem that to get wonky is orthogonal, right? It's a different dimension of the access to justice crisis. than if I can get to court or I need to think about whether or not to get to court, who can help me figure that out? That's a different thing entirely. But you're right. I mean, if somebody can convince me that I need to go to court and then it's going to be 9 months until I can resolve the custody issue or get my back wages, how good is that, right? That's another element of the crisis. That's absolutely a public responsibility because it's a public justice system.
Okay, I'm gonna ask one more thing and then other people can jump in and I'll wait my turn on the wheel again. But I think one of the things, and I know the other committees coming up to talk about it, but they're, you know, our roles are inevitably gonna intertwine. You had Walmart up on that slide. And then you were talking about, okay, well, there's, you know, there's your dog groomer, and then there's your dentist, and in between there's a little law firm. There's a huge difference in my mind between Amazon law, Google law, you know, the you know, AmazonLawyers.com, and someone who's, you know, you can walk into next to your dentist and talk to them. How do we take, again, how do we take the role that we're talking about and not, you know, maybe they work in a law firm and that kind of thing, but what if, how do we prevent an Amazon from hiring people, you know, training these people overseas? And then do we want that? Do we want an Amazon.com, a Walmart.com? Is this how our role of these paraprofessionals is going to make that efficacious? That's the wrong word, economical.
So that's a really interesting question. I mean, the reason Walmart law, so let's set aside .com for a second. The reason Walmart law could be a good idea is many effective outreach strategies work by reaching people where they're already going. So Tennessee has this thing called the Faith and Justice Initiative. And the idea is when people are in trouble, they go to their faith community, whatever it is, and they ask for help there. So how about we train, think of that as the front line of the justice system, and train pastors and church secretaries and so on to understand that when a woman comes in and says, Pastor, you know, my husband gets so angry, I'm kind of afraid of him. Can you pray for me? Maybe there's a legal issue in there. And so maybe that person could understand that that particular parishioner needs a different kind of assistance and refer them out, right? So you embed access where people are already going, which is why Walmart works, because people are already going there. The .com issue is a really interesting one. And I haven't seen this happen yet anywhere. That, for example, you would go to other jurisdictions, you would certify people somehow. I mean, you're controlling the certification, so you could say this has to be a U.S. accredited paralegal program, or a paralegal program accredited in some way, right? You set the terms of that, but that, let's say they're all from California. Amazon buys them and does stuff online. There are a couple of issues there. So one is, I'm not sure that would necessarily be bad. Many state court websites around the country, many law help websites provide really sophisticated form filling programs. What if you could actually get advice from somebody about which form you needed to fill out from that? And that, I mean, that would be an entirely web-based service, and it would be limited in its scope, but it could be very valuable for people in different kinds of situations. But I don't see why it would necessarily be terrible. The other thing is that there are lots of people who don't want to use the internet to do stuff. Particularly older people, but people who are in a situation where they want to talk to another human being and get some kind of a read and a check on the understanding of the situation. And online doesn't work for that for many people. The other data point I would share is, even if you look at how people look for help, many more people use the internet than did 20 years ago, obviously. But if you look at, once they decide that they want to hire an attorney, how they pick the attorney, it's a personal recommendation from someone they know. That is still the way that people navigate these kinds of situations. And so, you know, the online world provides a lot of opportunities, and I think you're right to think about how can we set this up so that whatever pops up online protects, you know, we're protecting people from fraud, from exploitation. But also, I don't think it's gonna be a long time before it takes over everything. I mean, Jeff Bezos would like to have Amazon law, I'm sure, but It'll be a long time before he can capture such a
he's
huge part of the market.
He's already working on trademarks. He's already got things out there for trademark lawyers that they're partnering with and making active recommendations. So I don't think it's good. I don't know. I might want to take a peek, do Amazon trademark and on Google, and let Google know you're doing that by typing it in the the Google. Anyway, I could talk to, honestly, let me let everybody else go, because I have, you and I could talk for a long time. Go ahead.
Sure. Julie.
Thank you, Professor Sandifer, for sharing your time and your expertise with us today. I have a two-part question. You seem really familiar with the programs in other states which have established them. For example, you were talking about Utah. I think it was Utah. And I wrote down that Utah requires paraprofessionals to submit a lot of data on a monthly basis to identify harms and then act on them. You need to monitor how the program is working, and if it's not working, then you need to fix it. Could you share with us a little bit more about that, what data they require in Utah? And also, I'm familiar with Washington, and I know that Washington sunsetted its program, and it doesn't seem like Washington sunsetted its program because it wasn't working. Based on the gathering of that kind of data, it seems like more of a financial issue, that maybe there weren't enough paralegals triple LTs to pay for that entire regulatory program, and the lawyers were sick of cross-subsidizing it. So I was wondering if you could comment on those two things.
So I sowed confusion. So Utah has a paralegal program that licenses you up front and then lets you run. It's not that old, it's a year old. The context where you're monitoring consumer protection in an active way over time is a thing they call the sandbox. So that's a place where entities can apply to have two different kinds of rules relaxed on their practice of law. So one is non-lawyer ownership and fee sharing, and the other is using people and things that are not lawyers to practice law. Could be limited, could be expansive, whatever. You apply, you're approved to enter, and then the risk level is assessed basically on how far your model departs from the traditional practice of law by lawyers. So as that risk level increases, I think I sit on that regulator. The highest level we have so far have observed is moderate, is high moderate, I think. And so if you're in a moderate or high moderate risk category, you have to report monthly on, everybody has to report consumer complaints and receipts and the number of clients served, but you have to report on legal outcomes, financial outcomes. You have to have the first 20 cases that you do in the non-traditional model audited. You have to be open to secret shoppers who might check in later on to see how you're doing. And so that opened. So the first entities entered there October 1. And the first month of data will come in at the end of this month. And then we'll start to see a couple of things. So one is, how does it look? Because right now we don't know, right? We don't know this stuff for lawyers at all. So how does it look? And then how good were we at guessing what to measure, essentially, in this first pass?
So is the paraprofessional program part of that sandbox in Utah?
No, it's outside the sandbox.
Okay.
But an entity could say, I want to have the paraprofessionals come in and do more than they're permitted to under their license. I want to have them, I don't know what that would be, but within the court rules, right? So like you couldn't, I'm not a lawyer, I'm not a certified anything. And so I couldn't appear in court, even in the sandbox, because the sandbox doesn't control the court rules. The sandbox only controls the rules about ownership and who's delivering what kinds of services.
Okay. And do you know
why?
what?
The second question about the triple LTs.
Yeah.
Yeah. So there were a couple of, Tom Clark for the National Center for State Courts and I did an evaluation of that project a couple of years ago. And you're absolutely right. It had very slow growth. And so it cost about $400,000 to stand that project up. And if you've got 32 or 38 people paying their licensing fees, they can't possibly compensate the state bar for that. So there was definitely a financial issue there. And the reason it grew, there were a range of reasons that it grew so slowly, but one was that it was so heavily regulated up front, right? And there were the capacity to create the people who could fulfill that role wasn't entirely thought through when they opened it. So you had the supervised practice rules, you had the community college paralegal degree rule, and then you had to do a year of family law courses in a law school. The only law school that was willing to do it was UW. And they had a capacity of like 6 people a year because they didn't have a way to provide financial aid for that. It had to be done through their continuing education model, just the infrastructure. There was this huge bottleneck for that last part of the training. So that program could never grow very fast. And that's another thing I would really, so if I were going to advise this group about how to do this, like there's no reason that you can't take law school faculty and bring them to the community colleges and have them deliver that part of the content, rather than trying to run that through an institution that is just not set up to handle that kind of, not just the training, but like the model of the student.
Thank you.
Sharon.
Thank you. I have actually 2 more bites at the apple. I am really, really interested in consumer education. So those who do not recognize their issue as a legal issue, or they don't seek legal help for other reasons, or as you mentioned, some are very scrappy on their own and they solve some of the issues on their own. I know that your study shows that opening up consumer choices helps with some of that. Do you have other recommendations on how to educate the public about the wide array of services that might be available to them? So like if we had a paraprofessional program, how we equally promote that as an option, promoting also free legal aid as another option, and putting it out there so that consumers fully know what's available to them and can make an informed choice. And part of this is also looking at the current system of LDAs and accredited representatives in the immigration space and how to distinguish those services from a paraprofessional program.
So I think that's a great question. I think sort of at a high level, what we know about effective outreach to consumers is that it follows the 4 T's. So it's targeted to the problem they have as they understand it. It's timely in the sense that it responds at a moment when they realize they have an issue. It's through a source they trust, so they believe that whatever this is means well by them, and then it's transparent about what's going to happen. And if there's a cost, if there's the cost is kind of stated up front. Consumer education, so that's like really helpful and awesome, but it also makes it kind of challenging. So I did a presentation last week where I was sort of giving some examples of those strategies. So Montana Legal Aid, Montana is a big rural state. It has a lot of people who spend a lot of time by themselves and they like to hang out in bars. And so Montana Legal Aid created a set of bar coasters that have a question on one side and an answer on the other. Like, my ex-spouse didn't pay our credit card debt. Do I have to pay it? You flip it over. Sorry, yeah. But here's what you can do, and it has their website. The city of New York is really interested in preserving low-income housing by preserving tenancies. And so they have a public education campaign that essentially gives legal advice through signs. But since it's a sign, it doesn't give legal advice. So it'll say, if your landlord tells you you need 3 months rent as a security deposit, you tell your landlord, the law says security deposits can only be 1 month's rent, right? And those signs they're on the subway, you see it on TV, shows up in the newspaper. And so they're very targeted to specific issues. And they tell you the specific thing to do. Now you're raising another issue, which is that, so we create all this choice. Consumers have no idea about what the legal services market looks like now. If you put another 10 things that they could go to, they'll have the same no idea about what it looks like then. And so what's the way to help them understand that they have a lot of choices? What Washington did, which I think is understandable but was a mistake, was they said, okay guys, go out there and come up with really good business models, go. And of course, these are people who have not I mean, lawyers are terrible at running practices and thinking about how to do outreach and stuff like that. And so why would we expect that that these other certificated professions would be that way? So one thing to think about is when you create the occupation, is there some training you can offer that says, here's how to help people figure out that you're here and what you do? And then there's another question, another issue, which is once we connect with people around the problems that they have, how can you let them know you could go to legal aid? So for example, is California law the place where this information lives? Is the state bar the place where this information lives? Is the sports website the place where this information lives? Right? There's a set of people, now that you know you have a problem with the legal aspect, there's a set of places you can go for help with that problem. And here's a description of what they do, and here's a link to them. So I think that's one thing to think about. I think another thing to think about is that particularly, there are lots of services that people reach through community organizations of different types. So tenants unions, immigration rights groups, that kind of stuff. Can you like embed the information in this so that that's the trustworthy, timely thing? So I know I'm about to be evicted. I go to my tenants union. You say, well, you could hire an attorney. You're not eligible for legal aid. You could also do this other thing. Sort of multi-pronged outreach strategies, because the one thing we know is that people are terrible at doing the following thing, which is reading a big book about all their rights, and then at some point in the future, applying that information to their specific situations. I mean, if you look at legal knowledge, it's increasingly unrelated to education in really powerful ways, right? So nobody in this country knows anything about rental housing law. I don't know why, because most people have rented, but they don't understand security deposits. They don't understand rent withholding. They don't understand conditions violations. And it's not because they're not smart people. It's just like, why would I know this unless my life somehow brings me into a situation where I need to understand it? And so finding ways to target people with problems as they understand them, and then connect them to some source that lets them know there's this range of options, I think is the general principle. And there are lots of different ways to do it, but it's also hard.
Thank you. I've got one more question. In your study, where you were looking at paraprofessionals and lawyers and asking about satisfaction and effectiveness, were those paraprofessionals supervised or working with lawyers, the ones surveyed?
So there are two sources of information about that. So one is the study that Tom with the triple LTs in Washington, and some of them were independent and some of them were parts of law firms. But even when they were parts of law firms, they had an independent scope of practice. So they didn't go back. So a good paralegal will go back and like check. They'll know exactly what to do, but they know they're not supposed to give advice independently. So they go back and check with the lawyer. The triple LT didn't have to do that because they were fully empowered within the scope of their thing. So there were some of them that were doing the fully empowered thing in a practice, and some of them were doing the fully empowered thing independently. And we didn't. I mean, granted, we didn't. The program was small then, small forever, so it's not 2,000 that we're talking about. But there weren't differences we saw between those two models. Now, if you go to Canada, which had this really interesting situation, Ontario, where paralegals were running in the wild, unregulated and unsupervised. And then the state bar, the bar society decided, the law society decided we need to regulate these people. And as part of that, they did a study that looked at consumer satisfaction with those folks. And there are, in the UK, there's a thing, McKinsey Friend, who could be a paid or a volunteer person who can accompany you in court and give you advice and can't speak for you because they don't have rights. But if you look at satisfaction that compares those to lawyers, what people appreciate about the Canadian paralegals and the UK McKinsey Friends are, they answer my questions, they're accessible to me, they're like me, I was able to find them, and they tend not to say those things about attorneys. And so, consumer satisfaction with those kinds of providers is usually pretty high when the relationship happens. But to go back to your earlier point, getting the relationship to happen, especially when the role is new, is an actionable challenge that this group will need to think through.
Thank you.
Elizabeth.
Hi, thank you, Professor, for taking the time to present on these very important issues. I had a quick question. So in order for legal document assistance pursuant to Business Professions Code 6400 here in California, we are supposed to get a bond of $25,000 to help the public directly. Immigration consultants who also register with the Secretary of State are supposed to get a $150,000 bond in order to work directly with the public. And so we in this group have bounced around a couple of ideas regarding additional insurance such as errors and omissions, professional liability. And I was wondering, do you have any advice, suggestions regarding whether these are even necessary as, and if so, which would you recommend if you have any thoughts on that?
That's a great question. I'll tell you what I've seen done. So when Washington had the LLTs were required to purchase malpractice insurance. And there's a deep irony there because Washington lawyers are not required to purchase malpractice insurance. And lawyers in only 3 states are required to purchase malpractice insurance. So you might want to think about that. But then to this issue of a bond or some kind of security, in the state of Utah, the model that we've taken, I don't think the LPP is required to have that insurance, and I don't yet required to have that kind of bond. One thing that we have, the policy we've taken in Utah is that's a case-by-case thing. So if it seems risky enough that that kind of security is necessary, we might require an entity to have that kind of security. There's also another issue that I encourage you to think about, which is sometimes that provider has to hold money in trust for some period of time until something happens, right? So that's where all IOLTA money comes from. If that's something you want to, we're still figuring this out in Utah. If that's something that you want to do with this group of paralegals, how do you want to do it? So is it making somebody bond, or is it having a fund that goes into so that it's separate from their, the money of their firm? I mean, there are different ways to try to handle that. I know of no research that says which is more effective at consumer protection, which is the main point, right? So I know of no research that helps us make a decision between those models.
Thank you.
Julia.
So I have a question about, you were talking about or suggesting that perhaps the professors from law schools would be teaching some model that we come up with for creating the proposal for licensing and education. So we've taken a look at Ontario, Utah, Washington, and Arizona. And I really liked a lot of what I was seeing in Arizona. And so we have considered having some sort of an advocacy part of the education, but it was with the understanding, based on the 2 judges we had come to speak to us from Arizona, I believe that they are allowing the paraprofessionals to go to court. And I was also imagining that if I'm a paralegal professor, that I could also become a professor for this paraprofessional and would not have to be working in a law school in order to teach these candidates. So we're thinking they're not just going to be possibly paralegal graduates, but also law school graduates who perhaps are struggling passing the bar. So they may come with a law school education, they may come with a paralegal education, but we're pretty much envisioning it's going to be one of those. So the additional model that we're creating for education appears to be something that is going to be much more, depending on the areas that we decide for the scope that they can practice in. There's going to be a certain amount of education that they're going to have to test successfully into practicing in that area. And then there's going to be some other procedural type course that they should get in addition to what they got as, I mean, obviously you're getting civil procedure in law school, and you're also getting civil procedure in litigation. I teach in an ABA approved program. So there will have had some access to civil procedure anyway, but it's very different. Clearly the paralegals get more specific hands-on training. Law school does a lot more theoretical, at least when I went to law school. So what I'm contemplating is that they will be people who either, yes, maybe they're adjuncts at law schools, or maybe they're already working in a paralegal program, and that we could have these programs not just as continuing legal education for a law school, but actually in community colleges as well, and provided at a lower cost perhaps than you may have to pay if you took it at a law school. My question is this: does that sound like something that's feasible based on what you've seen? And number two, does the model in Arizona, based on what you've seen, permitting more access to these paraprofessionals going to court with the client?
So I think you're absolutely right to try to expand access to the education by putting it in a place that's more accessible to the people who would be using it. So by putting it in community colleges. Washington State made the choice to say you have to have these courses in a law school, not because they thought the public would care, because it were professors from practice. It wasn't podium faculty teaching about constitutional law, right? It was professors from practice teaching about how to do this specific thing. And so they could just as easily have done that in the community colleges or remotely to the rural community colleges. But the bar felt like the new role would have more legitimacy with the bar if the people went through law school in some way. So to your point, I think there are lots of effective ways to design the training, both so that the people learn what they need to know and so that they have access to being able to learn it. I think, do they need law professors? I mean, professors from practice are law professors, but they're not people who write for law reviews and argue before the state Supreme Court and stuff like that, right? They're people who are much closer to the actual work. I will say something else that I got from the triple LTs, and whenever I talk to paralegals, they tell this story, and it has to do with whether you come out of law school knowing what you're doing versus whether you come out of a paralegal program knowing what you're doing. So the paralegals would often use this expression that I thought was so quaint: baby lawyers. Well, you know, when a baby lawyer comes to the firm, you have to teach them how to do this and teach them how to do this. And so I think, you know, you may find that the folks who've only had the law school training are the ones that need the backup for this particular role. And the ones who've had the paralegal training are maybe closer to readiness to practice. I don't know if that answers your question.
Well,
your second question was about appearing in court. So these roles are so new, and their rights of appearance are so limited that there just hasn't been enough time to say, you know, these 5 people appeared in court with their clients and this happened in 4 of those cases. It's too early for that particular model.
So in terms of Arizona in particular, I guess I just got the impression from the judges that they were going to expand it as much as feasible to allow them to do a variety of things, which I was quite frankly surprised by. So I think we want to be careful when we pilot this program, but at the same time, be open-minded. And I guess maybe we may not need as much advocacy included, but I will agree with you, having been a professor in paralegal school and now, and obviously a law school graduate, the baby lawyer concept is, I'd say, nationally used in law firms, because generally it is the secretaries of the paralegals that are helping the baby lawyer.
And to the issue about, I mean, rights of appearance, that usually requires some court rule to be changed. And that's a slow process that involves lots of committees and then court voting. But every jurisdiction has always talked about that kind of expansion. What I will say is, in New York City, they had court navigators who were not advocates and they weren't giving legal advice, but they were permitted to answer factual questions that were addressed to them by judicial staff. And the judicial staff loved that because the client is often confused, stressed out, freaking out. And then here's this person who can say, the receipt's actually right here, you know. we can show that. So even really limited capacities to interact in the hearings, I think can be really useful in these kinds of situations.
Thank you very much. You've been extremely helpful to the group. Thank you.
Ira.
Professor, I have a question about paraprofessionals being supervised by attorneys. Before I get to it, though, the discussion just this moment made me remember that there's plenty of law schools in California. You know, we have all different kinds of law schools, unlike most states, including the school that I do work with. The professors are not academics. They are practicing lawyers who decide they want to teach. So this is in law schools. And so I can't see why we would need quote, law professors, academics to be teaching paraprofessionals. Anyway, Mike, I'm thinking back to the chart you had that was, it was about the United Kingdom, and there was orange and red, and then there was gray on the right, and you described the gray as the professional hitting it out of the park, doing an excellent job. And so what was being compared was, it was in the UK, so it was solicitors compared to some sort of paraprofessional. What sort was it?
So there are a range, in the UK, there are a range of non-lawyer advice providers who can tell you what to do, help you fill out documents. They can't represent you, though. They don't have rights of appearance.
Okay.
So
now,
it's all office practice at that point.
All right, so all those types of non-lawyers, were any of them supervised by lawyers or solicitors, as they call them there?
No, they were all independent.
Okay, the hitters out of the park were not supervised. All right, thanks.
I would just on the tail of what Arya just said, though, it's hard to find information about those UK programs, at least on the internet. How many of those below the solicitor professionals, how much of that is subsidized, like our self-help court or the New York Navigators? How much is that paid for by the UK government?
So there's a nationwide legal advice service called Citizens Advice. And that is basically, it's independent, but it's funded substantially by government. Then there are advice services that are organized for specific populations. So there's aid, youth, and shelter, which is not around populations, but around housing. But then there are, as I said, for example, will writing companies who send a non-lawyer to your house, which people love, to sit down and talk with you about what you want to have in your will, and they write your will. So there are those kinds of for-profit things as well. And then there's this very strange thing that comes out of a divorce case in the 70s, McKinsey versus McKinsey, called a McKinsey friend. And originally McKinsey friends were they were literally friends and family members who would, the original McKinsey friend was an Australian lawyer who therefore understood stuff about law, but was not eligible to practice law in the UK. And he sat with his friend who was getting divorced and gave legal advice. And there was a huge amount of litigation around that. And they decided that was okay. They can't appear, but they can sit next to you and tell you what to do. So that became expanded. So many people, there are non-profit groups of McKinsey friends that work for specific, like say Father's Rights McKinsey Friends or Domestic Violence McKinsey Friends. But then there's an association of paid McKinsey Friends, and you can hire somebody. They have a nice website, tell you their hourly rate. There aren't that many of them that are part of this association, maybe 38, 50, something like that. But you can pay them to come and give you legal advice and accompany you through whatever kind of legal process you're going through. So the rules permit a great diversity of those models. Because the government has invested in some of them, they have a scale that they wouldn't have without that kind of public investment. But they also, because the government has invested in some of them, kind of set the standard for what the standard of care for that kind of service. And that community citizens advice bureaus have been around for 60 years. They were a product of World War II. And so that's why if you're going to the United States, it's a terrible idea to say, let's not have any rules, because we don't have that benchmarking standard setting behemoth in the space that's publicly funded and publicly focused. And so then we have to figure out, since that's our context, what way to achieve that level of quality. So that's quality control through like modeling. How can we achieve that level of quality? What's the kind of regulation that we can have? And so that those services are good, and getting them is a good thing. But that, I mean, it's a great point about the different funding context, which is not just about money, it's about standard setting. And so we have to do it in a different way because we don't have that kind of investment.
Thank you.
All right. Any last question or comment by a member of the working group? No, okay. Well, thank you so much, Professor Sandifer. This has been excellent. And please do send any materials to me, and we'll make sure that we get them out to the working group. And for the rest of you, I'll see you on the 29th, if not before.
Thank you.
Thank you.
Good luck with everybody. And if I can ever answer a question or you want to have further conversation, just shoot me an email.
Thank you for the time,
Thank you.
Professor.
Thank
Sandifer.
you.
Thank you.